Ready today.
Good.
Besides ready to go to Pickathon. So I'm just calling up the agenda to get started. Do we have a quorum? And are we recording? Yeah, we are recording. Okay. Do we have
I don't have a chance to count yet. We need at least 5 of us. Looks like we got at least 5 of us, so we are good.
Okay. Okay. Fantastic. So let me just grab the agenda. One sec. Yeah. So today we're going to finish off our work in the issues document and then dive into the straw man legislation that Todd had prepared. So we've got on the agenda to approve the agenda, to complete and finalize, like I just said, the public records cost concerns document. We'll take some public comment after we finish discussing it, and then we'll use that to dive into the proposal from Todd. Include public comment, of course, at the end of that as well, and then we'll figure out what we're doing next. I want to just add very briefly, it doesn't have to be formally written down, but I got some testimony collected SPJ, which I've shared with Todd. I think I posted. I want to just draw everyone's attention to it. And I just wanted to check if anybody else had anything they wanted to bring to the new testimony.
Emily, sorry, you sent me testimony from SPJ?
Oh, did you not get that today?
No, I did not.
Oh, well, I apologize. I will send it to you after the meeting.
I'll get it posted on Tuesday.
Okay, great. Yeah, I started seeing a lot at 6 o'clock this morning. Anyway, I'll just share a little briefly about that. I wanted to let people know that was coming in, and just check if anybody else had anything else they wanted to draw people's attention to, anything they've been hearing from constituents or whatever. Okay, Steve, anybody else? Yeah. Okay, well, let me just describe briefly what Todd will be sharing out then on Tuesday. It's just some experiences that SPJ got from journalists around the state that reflect the different ways that costs are leveraged to impede reporting in their experience. So there's some specific stories that I think people will find helpful. It just makes it more, tangible than a generalized sense. So that'll be posted Tuesday and entered into part of the record. And then, Steve, what did you want to share?
First, I guess point of order. Can everyone who's now speaking please mute? I'm hearing kind of a echo or background noise or something. Hey, Michael. Yeah, so I had a document. I wanted to see whether it's appropriate to share into the record, or maybe it's I can share it here, Todd, or you could post it on Tuesday as well if you want. It's kind of a discussion document, informational, analytical document based on some research that I've done, just bringing some numbers to bear on costs based on what we know. It probably would be helpful. Well, I hope it might be helpful for today's discussion, but I only got around to completing it in the last 5 minutes. So I recognize if it's impractical to post it at this point, but I just wanted to mention that. You're muted, Emily.
Sorry, it's an analysis of what exactly?
It's an analysis of records costs and the fee collection based on data collected during the Public Records Advocates 2019 survey, and also we've talked around the ideas of automatic fee waivers, and we've also talked around the concepts employed in Connecticut, Oklahoma, and Kentucky, where essentially it's a default fee waiver 100%. And so what I try to do is put together an analysis of like what exactly that would mean for Oregon financially if that were to happen, based on what we know about current fee collections.
Oh, okay. So yeah, we can send both those on and enter them to the record, and then I just encourage everybody to have a look at those. That sounds like it'll be useful, Steve, to, since we're thinking a lot about money, of course. Okay, does anybody else have anything they wanted to, like, to testimony they're aware of, or anything that they wanted to add to the record? And then we can approve the agenda and go forward.
Emily, sorry,
yeah.
since we're discussing document faux pas, I did not post the updated shared concerns document until last night because I forgot that I had the updated version. So it's on the website now and available for everybody.
Oh, great. Thanks. That's appreciated.
What's the website?
Do you have your hand raised, Tyler?
Yes, I do. I just heard somebody ask what the website was.
Oh,
it's oregon.gov/PRA, and I will drop a link to the document in the chat so anyone in the meeting can click on it now as well.
Great. Thank you, Todd.
I did want to jump in, Emily. Thank you. But just on this note, I was able to connect with one of our members, and they were able to get me some preliminary numbers on some of the fees that they are charged, and sort of a breakdown, at least from one of their departments, on invoices that were for records that turned up 100 pages or less. So I haven't seen and I haven't vetted with this member if they wanted that officially submitted into the testimony. It was more for talking points, but I wanted to make sure that that at least for the record, know that we're out talking to our members, and happy to provide any info if it's the will of this group. I can track it down.
It would be great. Yeah. I mean, if you could, it's so much easier, right, to deal with numbers when we are able to read and digest things. So if that's something that you're, the member you're talking with is willing to put on paper and then get to Todd, then, we can, all of these will be available as we continue to think through things.
Sure.
Great. Thank you, Tyler. Steve.
Sorry, as part of my research, I also made some inquiries from different public bodies that collect fees. And one thing that'd be great, Tyler, if you haven't already, if it's possible to disaggregate the commercial versus other, like how much fees are collected from commercial versus other. I don't know if your source is able to break it down that way, but that would be interesting information to have.
I would be happy to ask if that's a possibility. Thanks.
Okay, great. So sorry, we sort of scooted that testimony updates and catching everyone up into the agenda without a formal bullet point, but and without approving the agenda. But so I think we're through with that part. So do I have a motion to approve the agenda as is for the rest of the meeting?
So move.
Second.
Great. All in favor, say aye.
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 Okay, great. Emily, thank you for the thumb. Okay, so the public records cost concerns document, I think we had one item left. This, Todd, is where one of us needs to share our screen and share that document. So I think I can do that by pushing the share tray, right?
That should work, and if not, I can share it.
Okay. Would you mind sharing? I only have a tiny screen today, and it's a bit much.
Oh, you know what? I only have a PDF up. If you give me a minute, I don't know. I don't think I have I don't have an updated Word version, so okay. I wouldn't be able to type in it.
All right, stand by 1 second. Okay, I have the document, my tired little computer, and yeah, okay, this looks like the right version. Okay, so I will now share my screen. Okay, so can people see this document?
Yes.
Great. So I believe the only one we did not get to discuss was number 14, looking again at the the affected parties and letting ourselves drift into possible solutions if we can not help ourselves, which has actually been very useful in many of these. But the number 14, the public records law, too often serves as the only access to people whose individual needs in a specific circumstance may be different from general public needs. Let's see, that I believe that was referring to things like that were brought up, particularly in the FOIA testimony of people who need their own records, like their own criminal report, their like an accident report, or things for a lawsuit, because for whatever reason, that's the best way to get something. That is my recollection of where this came from. Other comments on this issue, what else it would address, and who's affected by it, and how important it is in Oregon. I can't see anyone's hands. Oh, it's so terrible.
Michael's got his hands up.
Okay.
Hey, I'll just, I hate those digital hands anyway, so I'm happy to ignore them, Chair, if you can't even see them. No, I just wanted to mention another context we heard about was contested case proceedings in front of agencies, where it essentially takes the place of a formal discovery process in litigation. And yeah, to me, this is a problem that affects people more than agencies. Like, I view this as a problem for the public, and it often seems to me that it serves a little bit as a sort of a shield for agencies, or even like a tool to use to sort of make claims about the cost of the public records law that don't really hold up to much scrutiny, but maybe are plausible at first blush.
Okay.
Thinking about a particular city and its number of public records requests that it likes to tell us that it gets.
Oh, and numbers, not just costs. Numbers. Anybody in it from an agency have experience with this that might be able to get some light on whether to what degree agencies are affected by this? And anybody have any experience directly with this this kind of issue coming up? We're thinking of one city. How big of a problem is this?
I can.
Do people feel?
I don't, Emily. I don't know whether it's a problem, but I do know from reading the 2019 survey, there were like some state licensing boards that would treat a request, an out-of-state request for credentials, or proof of licensure, treat that as a records request.
Okay, so.
Yeah, and it came up in the context of like our child welfare discussion recently. That may have actually been on the Sunshine Committee, that we were looking at exemptions for family law related matters, and we heard from a child advocate community that, as the lawyers for the child, they're often sort of funneled into this public records request framework to get records that relate to the children they're trying to advocate for. So, I mean, I think it's a real problem, both for like sort of the policy areas where these laws apply, but also for like, just because to me it makes the whole public records law into a much bigger beast than maybe it needs to be.
Mm-hmm. So would the kind of solution then be addressing the public records law, or be addressing other areas of the law? Do you suppose? Imagine.
Yeah, I mean, I think I would want to address it probably by having sort of comprehensive look at like, well, what are these areas and how can we change the laws in those contexts to allow for access for people who need it, you know, without forcing them into this process that is not often a good fit. But I feel like the expert who talked to us didn't really like that idea. This is a long time ago now. And Steve, I think it was one of the people you invited who had written a book on this subject and who thought that, you know, really it's not great, but the solutions are worse. So that may be what we would find if we looked at it, I guess. Is that recollection consistent with yours, Steve?
Oh boy, I wish I could remember.
Well, if it's the
That sounds
FOIA,
about right. I mean, she used the example. She used the example of is it customs and immigration and people seeking various documents that support their immigration case, I guess. And she seemed to feel that was I think she said that was a proper use of FOIA. But yeah, I can't.
okay. Anybody else want to add anything? Oh, go ahead, please.
Hi, this is Cherie Lafour with Department of Human Services, Child Welfare. I had my hand raised, but I recognize you can't see it. So if it's appropriate, can I ask a question? And so I'd be curious to know if there was concerns about people accessing, you know, Child Protective Service records. I do manage our department's public records unit, and by far 60% of the requests that we get is for child welfare, Child Protective Service records. And although they come in centrally to the public records unit, there's a statute that protects those type of records. Only certain people can have access to them. So although a general member of the public most of the time would not get access to these reports, except in very, very limited situations, you know, a child's attorney is one of those people in certain cases has access. So we do look at it from, yes, a public lens, but it depends on who the requester is and what their relationship to the records are. So although they come into a public records unit, we still do release Child Protective Service records all the time if it's a person who is allowable under state statute to have it. So I'd be curious if there was a concern. I have heard it got way better since our unit was in place and was responding to those from the public records unit. So I would just be interested to know what problem we're trying to solve with this one, particularly if it's being brought up that it's child welfare. I'd want to know more about that because it's maybe something I need to help clarify.
That is great, Sri. Thank you very much. I think what the big picture issue that this brings up is not necessarily that people. I mean, part of it may be, as Michael was alluding to, and as the woman who wrote the FOIA book was talking about, maybe that by funneling into the public records request, it's makes it more difficult, or they have certain obstacles to get over to get their records. But I think the bigger picture way that this is relevant here is that should those really be part of the public record, you know, accounting for costs? Like if we're trying to figure out how much do public records cost, should that type of service, which is a very specific individual need, it's really, as you just said, it's only allowed for certain people in certain cases, is that an appropriate thing to count under public records? I think that's what I'm hearing as the way that might raise a concern, as well as the potential, which we'd need to track down to see if we were really trying to solve for that, whether that created an obstacle to the person going through the public records process. Michael,
thank you.
Is that right?
That makes sense. And I'll just say maybe it hasn't come to my attention as an issue because we actually don't charge a fee for an individual requesting their own record, even in the child welfare circumstance when that record really belongs to the agency and not the individual. We've made a decision not to charge the individual. Now attorneys, it's a little bit different, but that individual themselves, we don't ever charge a fee, even if it's a large request.
Right. So the question, I think, and just to circle back to Michael to make sure I'm paraphrasing this correctly, is that So should that request be part of the whole discussion of the number of public record requests that happen, the amount the agency does with no charges? Should that be part of the understanding of
Gotcha.
what are the costs, the data analysis? So when we're trying to figure out, what are the real chess pieces we're working with here? Michael, have I summarized that correctly?
Very nicely, yes, Chair.
Yeah. Okay. Any other comments on this particular piece?
Emily, you have 3 hands up if you can't see them.
So here's the deal. I can't see it when I'm sharing documents. Todd, maybe I should hand over the calling on people to you if you can see people's hands.
Sure, that's fine.
Thank you.
Emily G, go ahead, please.
So I thank the commenter, because I was thinking that probably in that circumstance, like for a child's records, that they should not be charged under the current. But I'm wondering if a possible solution to this would be if we were to include a proposal around like lawyers who are representing a client pro bono or who work for a legal aid nonprofit, being able to have like a complete fee waiver over records that are specific to their client. Because I definitely think that would be a concern. I used to work in legal aid as a paralegal, and that can be a real problem when you don't have funds available.
Steve?
I was wondering whether, in addition to just like how we account for the volume of records requests, what we consider a public records request versus something else, whether there's a potential for a logjam to be created by the overwhelming majority of requests if they are something like for something routine and standard, like say a police report, or for a certain type of document like a licensure document. If that's basically, like, I wonder in the records unit at DHS whether the moving those requests to the public records unit, it sounds like it increase the efficiency for delivery to that clientele, but does it then diminish the amount of time available to process other types of records requests?
If I can throw something in here, and it just crosses my mind, and I know that it's a sort of a unique population, but I know that there are some pretty bright individuals who have residences in our correctional institutions, and I suspect Tyler can confirm this, who are pretty bright and can really create some problems for government through records requests. So I just throw that out there as a cautionary tale. I don't have any solutions or suggestions at this point, but I know that there are some smart people in our correctional institutions that really can create some challenges with public records requests.
Emily, a member of the public has their hand up. Should we ask them to reserve their comment for the public testimony period, or would you like to call on them now?
Oh, that's fine. Yeah, sure. Thank you.
Okay. Clayton Simon, please go ahead.
Thank you for that. Steve and Mark, actually, just to kind of follow up on your comments. So I work for a law enforcement agency, and just trying to listen in and see kind of what the plans are. I don't also have a solution, but I do want to exercise that, or at least talk about the caution of loosening up some of this too much, because for us, there's a lot of intersection with, you were talking even specifically about child welfare cases. Well, police are often involved in that, and then on top of all that, for us, our records are not just the paper kind or our digital media, but we have videos and in-car camera systems. And in order to process a lot of those and give those things out, which we're fine with doing, it takes quite a bit of time. And we actually don't have a very large records department. And so, one request that, if we have a particular family that's, called for our services and we've been out there a number of times, can have an upwards of a couple hours of video that requires, a great deal of redaction and those types of things. And I just want to kind of put that out there just for folks to know, not that we're not willing, obviously, to find a solution that works for everybody, but just that in some cases, kind of like what Mark and Steve talked about, that workload does exponentially increase with just the amount of technology that we have coming to these incidents now.
Thank you very much for that testimony and for coming and keeping tabs on this. Are you talking about requests like what we're looking at right now, of requests of individuals for public records of their own particular cases? Or are you talking about records requests more generally?
I think a little bit of both. We, much like the other gal, forgive me if I don't remember her name, mentioned, we try not to charge anyone. We would classify, as a victim. We try not to charge them for anything. But if all of a sudden they now want to, well, I want to know how you handled all these other cases, and I know these are, them, that now they start jumping into kind of other realms. And so we encounter folks on all sides that might be looking for something very small just for themselves. And again, if they're a victim, we don't charge them for that. But if they start kind of jumping into other areas, then we have to look at what's reasonable, not just for them, but for us. And we always try and start with being reasonable. What does that look like? Yeah, so I know that answer is very wishy-washy, but that's the best I have, because we try and take that it depends. Obviously, we stay within the law, but we certainly want to help people. So we start there, but if I have one person doing records requests, one case with a few different videos and a few different police reports can take half of, if not the whole day, and obviously impacts other people's ability to get their requests in.
So this is exactly what we're talking about. So if an individual is coming to your agency to get records of something that pertains directly to them, and they're channeled into the public records request line, am I understanding you correctly that one of your concerns is that their needs would get in front of the line of other people who are making public records requests that aren't like something that is specific to their individual needs? Because this point we're discussing right now is that the public records law, does it too often serve as the only access to people whose individual needs to a specific circumstance are different from the general public needs? So am I understanding you right, that you might have a crime victim who comes and wants something, a lot of material, and it has to do with them directly, and it's making it harder to fill the other public records requests? Is that correct? Am I understanding you correctly?
Yeah, I think you're encapsulating that pretty well. Their request, if it's just specific to them, it could be very large, and we'd still look at what that looks like. But it could also venture in, if they start asking about, their neighbors, or hey, we had this incident, and then we had this incident, and I want these types of things, and it's related to mine sort of, but I want to kind of expand. That I guess I'm just trying to throw out there that whatever rules, whatever changes to the law that we have, there definitely could be an incredible workload change for some of our agencies like ours that doesn't have a huge records unit.
Sure. Yeah, totally hear you. We're hearing that a lot. And what I'm hearing too, that's relevant to this particular point, is that there's some times where an individual is coming to an agency trying to get things that are relevant to something that they need specifically, and then it starts to spill over. And so some kind of solution would need a clear line. Can you imagine in your agency, are there other ways to deal with individual requests besides funneling them into the public records queue? About themselves?
Well, some of it is more informal. I will say that kind of what you said there, typically where we see this most often is if we have someone who's maybe having some sort of mental health crisis, and we start seeing some of those records requests get very broad, and they start getting into areas, we try and be reasonable and accommodate where we can, and, tap into our behavioral health specialist that works with our agency and try and serve that individual in a way that's best for them and get them what it is that they need. But sometimes that obviously, as we crack open that door for them and say, here's what we're trying to do, we start getting some unreasonable requests. As far as the records process, I mean, it's pretty simple for us as far as either, requesting it digitally, showing up in person. And sometimes they reach out to us on the law enforcement side. And then we, again, we all try and work together as a team to say, hey, this is what they're looking for. Let's sit down, talk about what it is that, they need. And, do they have the means to acquire what it is that they really need? And so we do try and, again, strike that reasonable balance. Yeah.
Thank you. Thank you very much for testifying. Any other comments from people on the committee, on the council about this number 14?
Tyler has his hand up.
Thanks, Todd and Emily. And thank you, Clayton. I just wanted to put an exclamation point on that. It's probably worth putting on this number 14 on our document here that I think the logical extension of this is it's going to hit particularly public safety and law enforcement agencies. From talking to my own members, those are the groups that are getting the largest amount of requests. So it'd be really crucial that we understand the impact on certain agencies and don't inadvertently bog them down to the point where they are unresponsive by sheer volume as well. I just wanted to say thank you to Clayton for being here.
Yeah, but aren't we trying to talk about that? Like, we're not talking about expanding access to individuals to get public records. That's already there. What we're talking about in number 14 is people who may need records for their own individual cases, maybe gumming up the public records work. So I'm not totally sure if I'm following what you're saying about a new hit to law enforcement agencies. Can you clarify?
Sure. I guess I was reading through this and I was thinking if this, I guess to your point, Emily, I was thinking if this was providing some sort of new or expedited access, if we were doing like a tiered system of, hey, I'm requesting my own records, does that let me jump the queue? And then suddenly we're differentiating between types of requesters, and suddenly, some people are pushed to the front, some people are stuck waiting even longer. I guess I'm trying to understand the implications of if we were to move down a path saying individuals get expedited access, then what does that mean for the rest of the public record requests that are coming in?
I see. So you're imagining a scenario where it stays a potential, like you're putting up a warning flag for a potential solution that would keep them within the public records system, but give them some kind of advantage
Right.
in coming.
Yeah, and certainly not advocating, just thinking ahead to where this might be heading.
Right, understood. And just being to flag that there could create more problems or different problems we need to think through. Okay.
Madam Chair, can I just ask a quick question? I'm sorry, our previous questionnaire, Clayton, could I ask what agency you're with? I'm sorry, I'm not familiar with you and which agency you're with. It would help with context. Thank you.
Sure, I'm with the Lake Oswego Police Department.
Thank you, sir.
Yep.
Okay, great. Any other people who have thoughts about number 14? Or are we ready to move on to look at the draft legislation?
We have 2 members of the public with their hands up.
Okay.
All right, Cherie, please go ahead.
Hi, this is Cherie again with Department of Human Services. Just really quick, I thought of 2 other examples that are relevant to number 14, just for context. So to your point, Emily, I'm starting to get a huge increase in requests for from current staff or staff who no longer work for the agency who are looking for their human resource records. Now, historically, that's been handled within human resources, and now they are coming down the pike really through our unit because we've got a consistent process. We're meeting timelines. We've got legal letters that say why they can't have something. So to your point, there are times where, because my unit processes, yes, public record requests, but I'd say the volume of what we truly process are individual record requests. So you're right, I don't have 2 separate queues or 3 separate queues. I can differentiate. I do have a way to differentiate in our system between the 2 types of records. So you're right, I'm doing it first come, first serve, and looking to meet the same deadlines for an individual request as we would for public records law. So there's not favoritism, one person prioritized over the other. It's basically in the order received, if that makes sense. So HR records is one example. Another one is somebody looking for their own records, but then it expands to, plus I want the emails connected to said records, and emails really are a public record request, not part of that individual's record. So just giving a couple examples to provide some context.
So, and those would all be counted in whatever data tracking you do on how many public records you do and what at what cost. Is that right?
Correct. And again, I started to differentiate in terms of true public records versus individual, but we weren't always able to differentiate that way. I had to do a system modification. So I think I need to keep doing that, because I think it's going to be an issue down the line if I have everything mixed together in the same system.
Okay. Thank you. And was there a second member of the public who had something to say on this?
Yeah, excuse me, Coral Smith, and then Tyler has his hand up.
Hi, thank you for the opportunity. My name is Coral Smith. I'm the records custodian for the Oregon State Police. And I just wanted to kind of echo what Tyler and Clayton and Cherie had all said. It perhaps might be something worth noting for the size of the agency and the volume of requests. So for us, we also provide public records or reports to victims free of charge. So there is that. But we here also, the majority of our requests that we receive are crash reports. So as you know, OSP patrols the highways and freeways for the state. So that's the biggest volume of our records. We do, according to the DAS fee schedule, charge a flat fee, so they're $12.50. But we also receive multiple other agency requests, so we provide reports to DOC, DHS. We get a large volume of civil litigation requests, so those are either subpoenas or public records, but people needing police reports for those purposes. We also get a high volume of name scans, is what we call them. So, other public safety agencies trying to hire employees, we will provide any relevant information, pertinent to a background check. So, we have all these little pockets of requests that we receive since we are a public safety agency. So trying to break out true public records requests as their own sort of queue, I guess you could call it, might not make sense for the volume and types of requests that we receive. So just hoping to have additional consideration for that.
What do you mean by additional consideration? I mean, I think what we're trying to discuss here is like whether this is the public records request the appropriate place. I mean, you're already doing them, you're already spending the time on them, but we're trying to figure out is there a problem with these kinds of requests, like another agency trying to do a background check on a hire? Is it appropriate for it to go through the public records request? Does that give us a true picture of what the public records requests are, or should it be some other system? And so I'd love to get your take on whether you think the public records request is in fact the best way to handle this stuff.
Yeah, that's a great question. I guess I'm looking at it more so we are a large enough agency that we're lucky to have dedicated staff as a public records unit. And I guess my concern would just be that if we try to split it out, the same staff are working the same requests, and we work them in the order received for these multitude of types. And so if it becomes some sort of rule or law that they are handled or treated separately, have their own kind of queue or special handling, I guess it depends on who is working them, but it could be problematic in that, all these people that are also wanting records for themselves, like crash reports, now maybe they're getting pushed back and we're not working them truly in the order received.
Okay, I think I understand. That's great. Thank you.
Steve.
Steve?
I think the state police representative answered my question, but so it sounds like if I'm making a request as a member of the news media, it's treated in exactly the same way as a request from an insurance company for a crash report.
I would say that it's worked by the same unit. So our public records unit handles all of those, even the requests that are not truly a public record, if that makes sense.
Yeah. I guess my question would just be like, if requests in the public interest, like if we broadly defining public interest, but requests that one could argue are in the public interest, or at least are for purposes of news gathering, those, I presume those are a very small fraction of your overall requests you're processing relative to insurance companies or crime victims or things like that.
Yes. So yeah, so we'll review every request, and there, of course, are always going to be ones that are handled differently outside of the normal process. So depending on the time sensitive or, the nature of the request.
Right. Yeah. I guess one issue that we're looking at is not so much a changing of costs or shifting of costs. It really is, I guess, in terms of timeliness. If basically a unit is set up, 90% to handle essentially commercial requests or legal attorneys' requests, and then 10% of the time it's requests for the news media. Do the news media requests, even though they're a very small volume, do they have, are they treated in, should they have preferential treatment? I don't have an answer to that, but I mean, I guess I'd be curious, Michael, whether that is part of what you're getting at, is concern about, like, need to create lanes, or like the failure to create lanes, is that impeding requests made in the public interest? Is that part of your concern, Michael?
I definitely was not thinking about this in terms of time so much as when we talk about these fee issues, right? Which is the central thing we're trying to talk about in this community.
Thank you, Michael.
Can you guys hear me? Yeah, when we talk about these fee issues, what we hear from public bodies repeatedly is how much work this entails and how much volume it is and how much expense the public records law amounts to. But I feel like it's important to sort of look at that and sort of drill into it a little bit, because it really, what I'm hearing as we're asking these questions is that, well, a lot of what we're calling the expense of public records law is really just kind of the expense of providing basic customer service to particular individuals who happen to be interacting with our agencies, or public service, like providing services for people. And I don't think that that's the impression that the legislature gets, or that we've frankly gotten in the past when we're sort of talking about these fee issues. We're thinking about them from one perspective, right? Which is like general public's access to what's going on in government, media access to inform the general public about what's going on in government. And so we're really kind of just talking about, I think, two separate things is more and more what I'm starting to feel. Like the question about how much it costs for the public body to provide the basic customer service of making sure that a crime victim has a report, or that the child in a child advocacy matter, that their representatives have adequate information to like process the case and handle the case appropriately, doesn't feel to me like it should be chargeable, so to speak, to the sort of general public and the media access to the law. So really, I wasn't thinking so much about timing, and I definitely acknowledge sort of the weirdness of envisioning some kind of separate process. I wasn't really thinking along those lines. What really this is about trying to make sure we're talking about the same thing when we talk about the problem.
This is really, really helpful. I hadn't anticipated that we'd have so much to say on this number 14, but it's very helpful. I'm really appreciating everybody's piece that they're bringing to this discussion. Todd, you see any hands up still?
No, so I'll just add my own 2 cents, because I suspect you probably want to move on. I hear and feel what everyone is saying, and I think the biggest problem is that our systems of providing records as public employees are just not adequately funded at the outset. There's, as we've heard from many different jurisdictions, there's endless competition for the limited dollars they have. Increasing revenue is often not an option. And so everyone is doing their best to sort of like smash together all these different duties. So, OSP, their records unit handles requests from all different kinds of requesters, many of whom wouldn't fit in with what we'd consider a public record, yet they have to deal with this work. And so I'm going to jump the gun a little bit, but some of the changes I'm proposing are meant to incentivize leadership rather than putting the burden on the employees to improve their systems, so that maybe some of these lines of providing records can be separated or better invested in, or however you want to say it. And again, I recognize there are limitations around that, but I think to the extent we can bolster these systems at the outset might help them process what we are, what are actually public records and what we are focused on doing.
Great. Well, I hope I captured both the sense of who's affected and the ideas of not just solutions, but what to watch out for in solutions that were brought up here in these notes. Obviously, just to make it clear that the official record of this meeting and everything everyone said in their testimony is not intended to be captured fully in these notes in this document, but of course in the recording of this meeting and the transcript of the meeting. So just to make that clear. I would in fact like to move on to try to take a look at use the draft law that Todd put together as a starting point to start thinking about legislation and keep, with this framework, which I just want to reiterate, thank you everybody for taking the several meetings we've taken to do this. I think that we've gotten some clarification, some clarity around who's affected by what problems we see. And, the goal of this was to help us identify things we're trying to solve. And that would be this next step of the draft legislation. We would be aiming to solve things in legislation, and probably not everything this go round. But so this document isn't meant to go into a drawer now. It is meant to be our sounding board as we look at the draft legislation, as we talk through solutions we'd like to see. We want to be able to map them back. What is the problem we are trying to solve? So that's ideally what this document, which we can certainly add to in different ways as we go along, but that's the purpose of this. So we know what we're trying to solve as we get into draft legislation. So unless someone else would like to, add anything to this cost concerns review, I'd like to propose that we do in fact move on. Is there anyone who's not ready to move?
Order, Emily?
Yeah, yes, go ahead.
The next item on the agenda is public comment.
It is true, and we have taken public comment along the way. So my question about if anybody's ready, does anybody have any more comments on this, includes the public. So thank you. And Todd, I'll have to leave it to you to call on people if anybody's got their hands raised or making other. Okay, I'm not hearing or seeing any anybody who wants to add to this piece of the discussion. So let's move on to the next agenda item. Our next agenda item is to discuss this public records advocates for Todd's proposal. So Todd, I would love to ask you, let's see, have I stopped sharing my screen? Is this button?
Not yet.
No. See if I do that. Oh, I think I have now, right?
Yes.
Okay, and I didn't hang up. Victory. Okay. So Todd, I'd like to do this in sections, you guys, because there's just a lot to go through at once. I presume everybody's had a chance to read it over. I know a lot of people have made comments in it, so that's great. So, but can we go through like kind of section at a time? And I wanted to invite Todd to give us a little summary of what is in that section and what you're trying to do there, and then we can keep discussion, to the sections. So Todd, you want to go ahead? You probably can jump straight to number 3, fees.
I'll go
But-
ahead. You want me to go ahead and share it?
Yeah, please go ahead.
Or what if I could find it? Does anyone know if you can share a Word document? Because that's what it's open in, but I'm not seeing that as an option in all my screens to share.
I shared a Word document.
Right. Ah, got it. Okay, you're seeing it, everybody? Okay. All right, well, actually, I just want to start with section 1. Some of you know this better than me, but I do highly recommend as narrow a relating clause as possible to try to keep out any sort of mission creep or inclusion of other items. Obviously, when we turn this into the legislature, this becomes their bill, but to the extent we can maintain our relating clause and it can be narrowly tailored to the work we're trying to do, the less they might be able to insert additional items into the legislative concept. So I'm not sure the best way to do this because sections 3 and 4 that I'm just scrolling through now maintain the majority of their proposed changes, but there are quite a few. So maybe I'll try to take these one at a time. And then Emily, you can interrupt me with questions, or if anyone has something to say and it works better to keep lumping stuff together, I'll try that too.
Yeah,
All
and
right,
you
so
don't have
first,
to like read through the whole thing, but just like a little general sense of like what this would accomplish and what would the change be, I think would be really helpful just to also keep the public up to speed.
Sure. Well, first and foremost, the major change would be to create categories of fees. In other words, if fees don't line up as search, duplication, or review fees, you cannot charge those fees for recouping your cost for providing the records. Even if you're allowed to recoup actual cost, they would have to fit into one of these 3 categories. That's to help control the definition of what goes into establishing a fee. And then I thought it might be useful to memorialize some of the common practices we see amongst state and local public bodies, which is waiving the first certain amount of time of doing work and or the first certain amount of pages, or maybe you say digital data that's provided. The point of both of those is to incentivize requesters to make more limited, narrow, and concise requests. And I certainly recommend that if we're going to go that route, we consider a mechanism by which a public body can say to a requester, you've made X amount of requests within the last, say, month, and therefore you're not going to get the first 30 minutes of each one free. We're going to lump those together as if they're one, because we have to balance your request with our own cost concerns and other considerations. Same with transfer of digital data or pages. Next in this section is a question, which is, do we attempt to define in any way, shape, or form how cost is derived in addition to search, duplication, and review categories? For instance, some public bodies charge only the hourly rate of the employee who is providing the records. Others do the hourly rate and the wraparound benefit costs, both of which are perfectly permissible right now, but can cause confusion and lead to different fees for the exact same record, depending on which public body you are requesting them from. There are no fee to transfer records electronically. More and more records are being transmitted that way, as long as you're doing it, say, through a Dropbox or email and not doing something like a flash drive. I'm suggesting you don't charge for that, but if you have to use outside medium or media like a flash drive, you should be able to recoup that cost. A lot of public bodies, in my experience, are charging up to the total cost or asking for the total cost to be paid of records at the time a fee estimate is provided. I don't think that's what the law envisioned, and I think a lesser amount should be, or I'm recommending or suggesting a lesser amount be permitted to be recouped at the time that a fee estimate is accepted, and the rest to be paid at the time the records are provided. Right. Oh, and I did try to condition that a little bit to make it a little easier for public bodies, including that An inventory of responsive records and any exemptions that are going to be employed should be provided along with the fee estimate, so a requester understands what they're paying for and could perhaps further limit or negotiate their request at that time, and also understand what they won't be receiving. If a public body is attempting to incorporate other exemptions from outside Chapter 192, they should also state specifically what those are, because I've seen some confusion around that. Also, maintain the usual mechanism by which if a public body has not received payment within 60 days of requesting it, they can close it, or if a requester does not negotiate with a public body after a public body has requested clarification, that they can close the request then too. For paper records, again, maybe imposing some sort of limitation after before which you cannot charge, maybe the first X number of pages, because we've heard from a lot of public bodies that a lot of their requests are only for a few pages at a time. And so potentially, if in fact that is the case, then this might eliminate the charge for a lot of records if they don't charge for the first certain amount of pages. And then perhaps consider setting a fee for additional pages, because I've seen the amount range from very little to rather high per page costs, whereas for counties in Oregon, there is actually a statutory provision that sets the per page rate. I really don't know why it's specific only to counties, but it might make sense to clarify for all public bodies what rate they should be charging for providing records. So no, that's section 3A. I don't know if we want to stop there before we move on or not.
Let's stop there. I mean, what I want to encourage is that if there's things that in this section A that something in section B would directly relate this. I mean, let's keep our discussion as close as we can to these specific fee categories of fees, because the category of requesters, the tiers of requesters, that's a bit of a separate kettle of fish in many ways. So if we can give it a shot to try to keep our discussion on this, that would be great. Lots of specific points. Thank you very much for a great summary, Todd.
Sorry.
And let's just open the discussion. I can now see people and their hands again, since I'm not sharing a document. So I'd love anybody from the council that wants to jump in and share your reactions to any of these proposals. Love them, hate them, want to modify them. Yeah, Tyler.
Let me start with just a question. And thanks again, Todd, for pulling this together so that we have something to start tearing into. Just on the first bit, changing the language so that it would say search, duplicate, and review. And I see that you've noted that that's a more accurate statement of what public bodies can do. Are you seeing instances where public bodies are going beyond what you're contemplating under search, duplicate, and review?
I don't have any specific examples to share beyond that. I have been asked on more than one occasion, well, what exactly does actual cost consist of and how do we calculate it, including from what point to what point are we providing records and how do we charge for that? And so I think clearly stating up front, much like the federal law does, just merely what that would consist of, just eliminates any confusion. And for those public bodies that don't have or are updating their public records policy, it would just create a very clear boundary or parameters around how to set up their costs and then break them down without them having to sort of reinvent the wheel or worrying about anything else. It's black and white.
Thanks. I was just trying to see if we're trying to codify current practice or limit it. And it sounds like it's more the former.
Well, Tyler, I'll just add one other thing. I'm aware of at least one, maybe two or more public bodies that add a little extra on top, a little extra percentage to try to cover their cost overall. They seem to be in the outlier, but I don't know if that necessarily aligns with what the public records law entailed in terms of recouping actual cost. Adding an average across the board for what this type of request might lead to in terms of costs, I don't think actually matches with actual costs, because as hard as it is, it's supposed to be, in my opinion, closer to a case-by-case basis rather than for this type of request, we will always charge this amount. I understand averages, but it gets a little dubious when you start kind of adding a percentage on top of the actual staff time that went into providing a record. And to the extent that that exists, that would, these flat categories would help eliminate the ability to do that.
Thanks.
Emily. Emily? Emily, can you hear me? You've got your hand up.
I'm so sorry. I was trying to click unmute and my computer
Okay.
was going really slow. Okay. So I have some concerns around the 25% deposit limit. I think it's inevitable that some people wouldn't pay after the request was fulfilled, which would then cause other problems, potentially extra work to try to collect on those funds. And how would that collection work? Would it be referred to the Oregon Department of Revenue? Would the agency just absorb the cost? However that occurred, I think there'd be additional costs associated with that. And I don't think it would be in requesters' best interest if their request costs were referred to collections. I don't know if anyone has any more thoughts about that, but those were some of the concerns I had about that.
So, sorry,
Yeah,
the question is like, I want to make sure I understand. If they don't pay up in full and the request is done, I mean, clearly they wouldn't get the records, I guess, but then you're wondering, well, how do we get we already did it. How do we get the cost covered? Am I hearing you right? Okay, thanks. Sorry, Todd, go ahead.
No worries. The way the system works now is you don't get the records till you pay. The difference is if you pay no deposit, or if you just pay a short, smaller amount, you're required to pay the rest at the time the records request is complete and records are ready to be disclosed. So a public body would still not have to disclose the records if they weren't paid. But I just feel like it's perhaps even a matter of constituent service. More and more public bodies are leaning on getting the money up front, which alienates a lot of people, especially when a public body comes back and provides records that they feel are minimal or incomplete, or they say that no records were found, but they're still permitted to recoup costs. And now these people have gone ahead and paid all this money, and then they get an answer that, they're told the records are ready to be disclosed, and they just don't really get what they think they're looking for. And I don't know, there aren't very many other government services that you have to put a deposit down on. And I just think it's better to align public records practices with constituent service in general, and not have requesters pay most or all of the costs up front at the time a fee estimate is provided, rather than when the records are ready to be provided to them.
Emily, did you have some more thoughts in response to that you want to bring up right now?
I appreciate that. I'm curious what other people think. I mean, I do think then it would mean potentially that agencies are doing all of that review and redaction of records before they've been paid. And so they potentially could do a lot of extra work that they don't ultimately get paid for, and then the records also wouldn't be disclosed. It sounds like under this, though, there wouldn't be any kind of issue with collection, so that is good and a good clarification. But it would still potentially be an extra cost burden on agencies and an extra burden on employees. But I hear your points. I think that that's a tricky one.
Thanks. Looking at the other council members, Mark, I think you had your hand up next.
Thank you, Emily. I will sort of echo the other Emily's concerns on this subject. I do think that she has a very valid concern that I think the rest of my local government brethren and sisters would probably agree with. 25% is, and I like the idea, Todd, of a sort of a deposit, but I think a deposit has to be substantial enough that there's pain if you decide to walk away from the request that the custodial entity goes through a whole bunch of work, ultimately produces the requested material, yet the requester decides to walk away, that's a problem. And I think that that could present a whole bunch of problems, not only for those who are waiting for their requests to be resolved, but also from a financial standpoint of the public. Okay, so I don't know if 25% is the right number. It seems to me perhaps a little low. I know and understand and appreciate what Todd is driving at. I think we may want to talk about what that number what the appropriate number or percentage or deposit ought to be, so that at least the public body has some assurance that they will recoup some of the costs if the requester walks away, and the requester feels some pain if they walk away because they created a new demand on their government to produce materials that was at their request. So having put that aside, I also want to make a comment about this, and it sort of goes back to a statement that I think a lot of us would agree with, and that is that despite the fact that, you know, we have this statement that a public body may establish fees reasonably calculated to reimburse the public for up to and the actual cost, I think we need a lot more guidance on this, particularly if we want consistency throughout the state. I will at some point offer some language on this point alone about what you can and cannot charge for as a public body, to make it real clear across the state that here's where you can charge for and here's sort of the areas that you may not charge for. So let me give you an example. We have about 300 districts in the state of Oregon that are run purely by volunteers, right? So if one were to look at a public request that went to one of these entities who has volunteers, theoretically, you wouldn't be able to charge for a volunteer's time. Well, that's a problem because you are creating a new demand. And I think that what we need to some extent here is a lot more clarity and guidance to state agencies as well as local governments as to what you may and may not charge for. And so it will be my intent at some point at the appropriate time to probably offer some language that will really clarify to the extent possible what government can and cannot charge for in this process. Thank you for allowing me to speak.
Mark, that's great. So it sounds like the search, duplicate, and review you feel like isn't clarifying enough. Do you think you could get that ready, like, you know, for the next meeting in 3 weeks?
Oh, I have it ready today. I just have been reluctant in sharing it at this point. I think we're still a little early, but Emily, yes, I will be prepared to share that with folks at the appropriate time. But I
want to share it, like you want to share it with this other stuff that's getting added to the testimony on Monday, so people have it to look at and think about.
Well, what I would like to do is continue to talk about this language with my client to make sure I'm okay to put it out publicly. But I feel pretty strongly that it's pretty nebulous and leaves a lot to be interpreted as to what you can and cannot charge for. And so I really do think that it would help a lot of folks, both the public as well as government entities, in having precisely what it is you can and cannot charge for. And it will be my intent to share that, Madam Chair, at the appropriate time. I hope that's sooner rather than later. But I also have a bunch of other suggestions to this this larger document, and so I don't know whether we want to piecemeal it or do it comprehensively. I'm prepared to do it either way, but I don't think we're quite there yet.
Yeah, no, I hear you. just, I'm sure there will be lots of, I think you're right, that we've heard lots of people would like clarification on this. So I think I would anticipate there'd be a lot of discussion on it. So it'd be great to get some specifics on the table like earlier rather than later. So we're not like trying to hash something out at the last minute. So
No,
yeah, you're right, but
I-
hopefully it will be sooner rather than later.
My hope, my intent will be sooner rather than later, Madam Chair.
Thank you. All right.
Emily,
Yeah.
it's Todd. Sorry, Mark's comments made me think of a few things that I wanted to add, if I may, about this section.
Please.
And I must admit, it is kind of hard to sort of hit all the high notes going through it like this. So I hope people will refer to the comments on the side as well when doing their own reviews, because I tried to flesh out my ideas as much as possible in those notes to understand what my thinking was or the problem that was being addressed. But that being said, Mark, in reading the language from establishing costs, that a public body may charge up to the actual cost of making records available. The up to part is something I added as well, because I don't think public bodies always understand that they don't have to charge actual cost, even though most aren't really recouping their actual costs. They're certainly trying to, or at least they often try to, but some may choose not to for whatever reason, as a matter of culture or custom or policy. And I just think we would be better served if they understood that they didn't have to charge actual cost, but can charge up to actual cost. And I am a bit weary in response to what Mark said about creating too fine a circle around all of this to circumscribe public bodies in a way that doesn't account for changes in record keeping that's going to continue to evolve over time, which is why I more or less mirrored the federal categories of search, duplicate, and review, because right now those categories can apply to just about any type of record out there, and we don't know what the future has in store. So I like sort of better breaking up actual costs into clear, specific denoted categories and letting them know you could get charged up to that amount. But I'd be a little weary of going further, and that's just my opinion. But then just to add to this other section about only being permitted to collect a portion of the estimated fees at the time the fee estimate is provided. My goal here in pairing that with subsection 1, which requires public bodies to provide an inventory of responsive records and any exemptions that they will utilize for withholding records with the fee estimate, is that a public records requester can better understand what they're likely to get and what they're not likely to get, and therefore are more likely to agree with the cost estimate and or attempt to negotiate or further discuss their request to get closer to the amount and types of records they are seeking. And they would also be more willing to pay a deposit or a part of the fees at the time that the fee estimate and this inventory that goes along with it is agreed to. I'm not wedded to 25%. I just am opposed to a public body collecting the entire amount at the time that the fee estimate is accepted. But I think if we somehow strengthen that fee estimate with an inventory, so everyone clearly understands what records are on the table, more people would be willing to pay that estimate because they'd understand what's coming down the pipeline after that.
So what I'm hearing you say is that you are trying to jumpstart this thing we've talked about a lot about shared information, clarity, and negotiation, but you can only negotiate, of course, if you are talking about the same thing. But it sounds like you're trying to jumpstart that whole communications process in a very formalized structure from the beginning, with like, here's what we've got, here's what the fee would be, now we can talk. Am I reading that right?
Absolutely, and precise. And 2 more quick points to support that. One is a whole lot goes into creating a fee estimate. So these public bodies are already doing so much of the work ahead of time when the fee estimate is handed over to the requester, including especially for digital records, most notably emails. They are, by the time they provide this fee estimate, they maybe have even already collected all these records, have reviewed some of them for confidentiality as well as responsiveness. And so there really isn't, as I'm seeing it through my work, a whole lot of work left to be done after that fee estimate is provided and at the time they provide responsive records. So I don't think a lot is going to be lost here if public bodies no longer have the ability to collect all the fees at the time a fee estimate is accepted, because I don't think they're doing, a lot of the time won't be doing a lot more work after that point because they already know what their universal records look like.
Thanks. Let's see. I think Michael, you had your hand up next from members of the council. Go ahead, please.
I can't even remember now why I raised my hand. It was so long ago. I guess I just kind of share some of my general reactions to this section. A lot of it, I'm not entirely sure what of our problem statements it really lines up with, like specifying that may charge your fee means may charge up to your fee, or like putting words around what actual costs entail seem like, I mean, maybe those are good sort of common sense things, or maybe there's unintended consequences in there that we don't really have the foresight to identify right now. But I just, it's not really clear to me how those proposals relate to the problems we've been talking about. I think, you know, in these little arrows, we sort of get at fee waiver issues that seem a little more directly related. The deposit, you know, I don't know. Again, that feels like, I think public bodies currently do sometimes require deposits, don't often require deposits. I don't remember hearing anybody complaining to us about the practice of requiring deposits, or for that matter, public bodies complaining about collecting deposits and then not collecting the rest. It just, I don't know. My reaction, I guess, is this feels like it goes a long way afield from what I understood us to be focused on, really. Sorry, Todd.
Seems like housekeeping a little bit to me, but I don't know. Todd, do you want to respond?
Through my experience as the public records advocate, which is inevitably going to inform trying to create this concept, at every step of the public records process, there's confusion, dismay, and frustration from requesters and public bodies around collecting costs, but also the process in general. And I think to the extent that we provide extensive clarification and guidance without hamstringing the work of public bodies, we are kind of in this, we're required to do so, because if you can't just say you can or cannot collect a cost in this way without sort of providing a universe of information around that. And if the law is already confusing and ambiguous and leads to endless tension, why not attempt to spell out these steps that currently exist in as many different policies as there are public bodies in the state? And so, yeah, this is pretty nitty gritty, but I do see it as responsive to the concerns we heard from the different people who came and testified and all the material we've received. Because this, whether or not you like this concept, if it was enacted, there'd be very little confusion or question about how to recoup costs when providing a record. And a requester would have very little confusion about what is required of them and what they can expect from a public body when they provide a public record. So we can tailor this any way, either, you know, the full subcommittee and then PRAC feels comfortable with. But I do think greater clarity that it still allows for a public body to do its work and react to its own individual circumstances is the way to go here. So to Michael's overall concerns, it just could be a matter of style, substance, and experience. And I don't really know what else to say to that.
Thanks, Todd. Michael, do you have any follow-up questions?
I mean, I do have some experience in the public records law, but it just feels to me like this is going to be, like, we're going to make our work coming up with fee solutions is going to be hard, and doing a bunch of housekeeping at the same time feels like it just is inviting attacks that we're not anticipating on subjects that aren't even really important to the subcommittee.
Okay, noted. Steve, you are next in the queue of council members.
I have one substantive point and one process question. So this document is a Word document that's being passed around. I'm wondering if there's some shared environment where we continue to make comments like Mark suggested. I mean, it seems like if he has suggested language, this would be maybe an appropriate place to share it in the document in line. Do we still have some sort of folder like that that enables us to do that?
That's
Well,
Great.
Emily, correct me if I'm wrong. Didn't we leave off with, I think based on my review of what was available, Google Docs was ultimately the best option, but some people did have concerns about using that as a shared environment.
Yeah, we couldn't do anything through the state that made any sense.
Exactly.
So that is not a blanket statement. That is just a small statement about document sharing in this environment.
Welcome to our world, Emily.
So the Google was it just access, or was it, I mean, one thing is you have to be signed into Google to do it, or else it's anonymous, and anonymous comments are difficult to deal with in a public forum. You can sign them, but your name isn't attached to them in the same way, but that's overcomable. And then but you would need some kind of, well, no, you can make it general to the public. I guess you don't have to have a Google account, but then again, you just have to sign in. Or was it that it's a potential meeting if like members of the council are all in a document, even at different times? I can't remember exactly what the concerns were, but yeah, we definitely need some way to, you guys deal with legislation writing all the time, you people who do, like, how do you do it? Like, what's the best shared way? Because we could take different things and, I mean, I know when you're revising stuff, right, you do the bold as the new, you strike out as the old. So maybe we just do that on a regular basis and update a doc. And what's the best way? Who's got ideas on that?
I just, one thought in terms of the meeting law issue. I mean, if at the very least, if we had access to this document during our meetings, and we could share comments in real time or add language in real time, if the concern is that we need to be all together and public to fulfill meetings laws in our deliberations, then I suggest we go that route and not add comments outside of the meeting.
Okay,
Well,
turn this into a Google Doc the next time. I'm sorry, somebody just spoke.
Oh, it's Todd. I'm sorry. Well, shouldn't we then proceed the way we have been proceeding, where we all offer our ideas, then you write them down, Emily, in the document? If we're going to do it together.
Yeah,
So,
we could do it that way for sure. Is there a concern
like,
about breaking public meetings law if it's accessible to people outside of the meeting times? Is that a problem?
I suppose we could run afoul of the serial meeting law if people are reacting to other people's comments and then writing their own comments based on that. Can't say I know this issue well enough to be sure. Maybe Michael or someone else does, but that we could potentially be in trouble if we did it that way. Everyone could send their comments to me and I can incorporate them into a single document, which might get very large and unwieldy if we have like 5 different versions of the same section, but we could try that too.
Who's done something before that works? Mark, you write a lot of legislation, right? What works?
Usually my way.
No, that's the wrong answer. What's your logistics way?
Well, okay, all kidding aside, this is kind of a unique one because I'll tell you, there are a lot of cooks in the kitchen. And when I write legislation, Emily, usually it's from my perspective, right? Or my client's perspective. So this is a little bit unique circumstance I think we're sort of in. My sort of sense is that I think that it would be probably wise to break these down into sections. And if individuals have suggestions on individual sections or subsections, that they provide that input individually. And I think probably working through each individual comments related to the specific section that we're talking about, and have a discussion to see whether or not there's an ability or common frame that we can all get to. I think that that's going to be challenging, but I don't know if there's whether there's a better way to do that, Emily. I just don't, because there's so many cooks in the kitchen on this one. I just feel that everybody's perspective is important here. And I think that if you have suggestions for a specific component in the straw man that Todd has put together, put your pen to paper and submit it to either the chair or the vice chair of the subcommittee, and let's make sure that we go through each and every section and everybody's comments. I think that probably what we're going to need to do is set a deadline. If you have comments, suggested language, or whatnot on section 3 related to fees, your comments need to be due back to us by XYZ. And this meeting, we will be discussing this topic.
Yeah,
this area.
The deadline piece is important, and then we can put things side by side, right? So it's because there will be, it'll be, if somebody's got something new they want to put in and somebody else wants to cross it off, it would be really, really messy to have it all in one paragraph. So, okay, I'm going to think through those deadlines and consult, and let's get something out to members early next week that breaks down a schedule on that. Steve, I hope that addresses some of your logistic questions, but you had something else you wanted to, right?
That's helpful. Thanks for, that sounds like a good plan. On the cost estimates, I think it would be helpful, and in addition, there's really no kind of guidance to any public bodies about what a cost estimate must entail, and detailed cost estimates can really go a long way toward the requester understanding the nature of the job that the public body is up against, and can facilitate a discussion about ways to reduce costs. And so I think it would be helpful, I don't know what the language is, but a way of somehow setting out some sort of norms around cost estimates. It also prevents just sort of, well, that'll probably take a year, and a year's worth of this person's time is $1 million, or, well, not $1 million, sorry, $100,000. So anyway, that would be helpful.
Okay, thank you, Steve. Tyler, you are the next in the queue. Please go ahead.
Thanks. I wanted to circle back to Michael and Todd's discussion a little bit, and I'll take Michael's tack and just kind of share some general thoughts on this section. I think that Todd was pointing out that it's confusing at every step for all parties as we go through this process, and I would agree. And in my mind, if we go back to the goals at the top of this document, I do think that we are going to, move towards cost reductions for requesters if we have more clarity. So I just kind of wanted to push back gently on the idea that, I guess what I would ask this group is, remember, we don't want to make perfect the enemy of the good. We want to, move slowly, steadily forward. And I think what that's going to entail is making tweaks that may not feel like we move the needle until we've seen if they've moved the needle or not. And so in my mind, if we tighten up definitional examples, and then we can take a look over the next year and say, are bodies using those examples? Are the fees that they're charging in them appropriate? Are they reasonable? Have we fixed the problem or not? And if we haven't, then we take our next bite out of something. I also think that having been around a number of advisory groups before, I think we also should consider the merit of doing something bite-sized that we can all agree on, just to bolster our own reputation. If we want to become the clearinghouse for public records stuff and not have people going around this body, I think it's important that we're a united front. And reasonably, I think that that's going to mean that we do things that feel minuscule at times, but if we're slowly and steadily plotting a course forward, I think that that's the way we should treat this. So let me start with that, with the spirit of yes, we need to get to yes, and it's my hope that we can do so slowly and steadily. And to that end, I'll circle back to Michael's point. I felt the opposite. Frankly, when I was reviewing this section with some of my members, hackles were raised very quickly at the arrowed section. We have examples of people who try to skirt, fee waivers by submitting under different names. And of course, we've talked before in this group about how we don't want to question why or who somebody is to receive a public service. So I get a little worried about those arrowed points, but I do think that there is value. And I think long term, we could reduce costs if we were all speaking the same language around public records. Particularly, I mean, I think that this would catch some of the outliers who are throwing on a fee that's that's vague at best, that gets slapped onto a receipt. I see getting more clarity akin to getting sort of an itemized receipt of your public records, and that leads to more accountability than just a blanket, here's what it's going to cost you, pay up.
I'm muted. Sorry. Thank you, Tyler. I know that there's a couple of members of the public. I see Mindy and Eric who have your hands raised, and so please acknowledge that I see you. You're in the queue, and I have a couple questions. And if I want to circle through all the council, and then we'll definitely save time for your comments. Appreciate your being here and sticking around. I had a couple of questions, Todd, just points of order, really, to understand, if you don't mind. If we clarify that you can only, recoup actual costs, would that have any effect on the flat fees that we've heard have been so efficient for many organizations to do, like a 1250 OSP report, for example?
It's unclear, Emily. I mean, again, that could be an aggregate of their cost for producing that type of record, that they've done a workflow analysis in the past. To the extent that it's connected to that analysis, it's likely to be able to be considered up to actual cost, but it's hard to say for sure.
Okay. Another question I have is the idea of lumping requests together, like, for example, if you've made several small requests, we're going to count those as one, and then thinking about what's waived, as grouping those things together. How does anybody see this? As it sounds to me almost counter to the idea of encouraging people to narrow their requests, right? Because if you submit several narrowed requests, which we've heard a lot of, there's like pushing toward that, then, but if then the flip side is, oh, but we're going to unite all these, and then we're not going to do the first 30 minutes free because you've asked for 4 narrow things, like, are those ideas fighting?
I don't think so, because it's meant to formalize advice that I currently offer public bodies that deal with what you might say are problematic or vexatious requesters. So because a lot of public bodies do offer some sort of waiver of their initial time of work, or a paper that goes into providing a request, they deal with requesters who then submit request after request after request over a very short period of time that are potentially attempting to game the system, or just don't understand that they are overwhelming a public body by seeking information that they're perfectly entitled to seek and that is important to them, but they don't sort of have the ability to be in this give and take relationship with the public body for whatever reason, in terms of submitting a request, getting records, and using those records to build on a subsequent request, or merely just waiting to submit the next request. So to the extent that a public body can aggregate a requester's request over a certain period of time to affect whether or not they can get like subsequent waivers of time for their preceding requests after the first one, I think helps pump the brakes for requesters that aren't able to sort of pump the brakes for themselves, and gives public bodies some tools within the public records law to push back on requesters like that, to say, hey, you're entitled to make these requests, but just so you know, we got 5 from you in these last 2 weeks. And so, our policy says or the law says we're going to count that as one request for purposes of any reductions we offer, because it's overwhelming our system. It's affecting our ability to provide records requested by other requesters. It's affecting our ability to do our other duties, as most public employees that provide records often have other duties to do too. And I think it just allows for a little breathing room for both sides. That's sort of clear and direct, rather than me saying to a public body, hey, you can take that into account, even though it's nowhere officially included in the law, and you could use it as a communication tool with the requester to get them to take a step back or limit or slow down their requests.
How often does this happen, that somebody will submit a request every day?
I mean, I'm certainly aware of numerous what we would want to call vexatious requesters in terms of just the number of requests that they submit in a short time, and or their unwillingness or inability to understand what that does to the public body. It happens often enough that it's a pretty common anecdote that I come across.
Just on my sort of gut reaction, 30 days is a long time, it seems to me, to like delay public records requests. And I'm also wondering if—
Well, it wouldn't be, sorry, Emily, it wouldn't be a delay. It would just be that I'm a public body. I waive the first 30 minutes of my time. But if, you know, if you've submitted X number of requests over X number of days, those are going to count as one. And it doesn't have to be 30 days. That's just a blank period of time I put in there as a suggestion for everyone to kick around.
Yeah, good. I know skits. It's a good. We always need a starting place. I guess I'm also you know, wondering if a couple of these are you know, we've talked about how we don't want to legislate for the extremes, right? And so a couple of these points that you've suggested seem to be trying to address a quote unquote vexatious requester, you know, what you just outlined of limiting the waiver of time if there's multiple requests. That came up also in the idea of the deposit, like if people walk away, you're trying to prevent people from racking up costs and then walking away. And I'm just wondering if, I mean, we have heard different ways to deal with truly vexatious requests. And these are raising flags for me as like the heavy hammer for the extreme situation that then would affect people who are not falling in that category. So I want to just put that out there as like, we clearly have heard a lot of struggle with and concern with quote unquote vexatious requesters, but I think we've also discussed how that is not where it's the most effective place to legislate for the extremes. That if there's true extremes, we need to perhaps deal with those in a way that doesn't catch everyone else in their net. So I just want to put that out there as an initial thought that comes to my mind looking at this. And then I just had a quick question about did you say the counties have a maximum fee per page or a minimum fee per page? And was that the 25 cents per page, or is that just a for example that you put in place?
I'm looking for where I wrote what the counties pay. Oh, it's here. It's ORS 205.320 subsection 1DB. I don't recall off the top of my head what it says per page for counties. I could open it and take a quick look to remind myself.
I can look now if I did. That's where the place is. Okay, no problem. Thank you.
Okay. And Emily, I just want to say, you know, the other thing is I think by putting clear rules around the system, like it's essentially putting bumpers on a lane when you go bowling. Yes, it's meant to prevent the extreme thing of like your ball maybe jumping out of the lane, but it's also meant to keep the ball moving smoothly down the lane toward the pins. And so I think just outlining giving greater detail sort of keeps most requests flowing smoothly. Like, let's say a requester who's new to making public records requests has all these different ideas about what they want to do and goes on a public body's website and looks at their policy and says, they'll waive the first 30 minutes. So maybe, let me drop a few requests on them for these different issues I'm thinking about. And then they see, actually, they're gonna put these together if I make too many over a short period of time. So again, it just allows them to consider how they want to either refine their request or space them out, or maybe wait to get information from the first request before submitting additional ones. And I don't think it's really going to disincentivize the majority of requesters who, you would say make an average number of requests at a time.
Do we know what an average number of requests at a time is?
I would say probably one at a time for most requesters.
Yeah. Okay, I hear you. I guess I have heard testimony on how agencies, feel the real need to maintain some leverage over how much, where their resources go, including public records resources, or particularly like in all this testimony. But I am cautious about putting, I'm cautious about the authority in the hands of the providers of requesters to decide, like, for example, if you could, you know, if you could lump requests together, well, then there's the opportunity for agency to decide, well, I'm gonna lump them together for this person, but I'm not gonna lump them together for that person. And so I think if we went that way with those guardrails, we'd want to be really clear that this applies to everybody, and there isn't, like, you know, favoritism. And then we'd need to think about, what does that mean to apply to everybody? Because I think that's a risk, when the power of, like, making a judgment call about the validity of a request based on many different things is in the hands of the provider and the holder of the request, the government, the public body. I think we just need to be very aware of that. And I'm not sure this would apply here, but that's a concern that has come up in other areas in testimony.
Well, I wholeheartedly agree. And really, my main focus here was trying to push more public bodies to waive the first portion of any amount of time that it takes them to provide a public records request, because really not a lot do, or at least don't do it officially in their policy. And I think more should, but I wanted to provide them with a tool to prevent that waiver of an initial amount of time being abused. So I was trying to sort of split the difference here and offer both sides a reason to find it favorable to waive the first 30 minutes or so of a public body's work.
Oh, that's really helpful to understand. Okay, thank you. Let's see, Scott, you've got your hand up. Would you go ahead, please?
Yeah, I just had a couple of thoughts, generally, not necessarily what you guys were just talking about. I wanted to apologize to the group. I haven't weighed in much at this meeting because I'm dealing with COVID at home, so a little bit of COVID brain. But I also want to say thank you, because when moments have come up in this conversation that I was going to say something, I felt like my thoughts on behalf of cities was well represented. So thank you to my friends in local government and actually across the council. So thank you for that. And I also wanted to express appreciation for the next steps that we talked about earlier logistically. So you don't see me right now because nobody wants to see this right now, but thank you all for a good dialogue today. And I am here and listening. So that's all I wanted to say.
Thanks. And I hope you feel, I'm sure we all hope you feel better soon. So thanks for showing up, even while you're feeling sick and have COVID. Tyler, and then we'll get to the public comments from the public.
Sure. Thank you. You know, circling back to what Todd had just said, you know, that not a lot of public bodies are offering fee waivers, and he'd like to incentivize it. It is worth reminding, I think, the whole council that the fixed revenue problem with local governments, and I think an indicative reason of why you might find discretion is if you look at the baked in the state constitution property tax rates that vary county by county, that are based, you know, after measures 5 and 50 on timber receipts that aren't there anymore. So the reality is that every county is going to be facing a different fiscal reality. And so I'm wary of taking a blanket approach that doesn't take into account those very real differences in structural revenue issues. And I'm worried that if we go this route, it might create a double-edged sword, where if we say you do everything, you know, you treat everybody the same under this policy, you might lose some of the discretion, where counties might say, you know, they might offer somebody who can't afford to pay a fee a reduction if we start saying everything is by the same policy, no matter your circumstances. And I would, from what I have gathered, I think more bodies like to work with requesters rather than say, everybody has to go, you know, under our policy, this is our policy, and we don't negotiate on it. So I'd be wary of giving up what I see as a way that requesters actually do save themselves on fees sometimes by preserving that ability to have some local discretion. But that being said, it's going to ultimately, I think, come down to the fiscal reality within each county, at least. And that's just speaking for my members, and I'm sure other public bodies could weigh in too.
Tyler, is your sense that kind of concern, which is very important, be addressed by things like you may recoup up to, for example, which allows for, but I think and you could certainly put in policy, I suppose, like if, you know, if you're on the Oregon Health Plan, you can get records at a discount. I mean, that could be something as well, but that would be a clear standard. The issue I don't have a radar out for is misusing leverage. So I appreciate the need to differentiate, but that's what my radar is. Okay, I promised Mindy and Joe a chance to talk about Steve. I see your hand up again, so let me just go to you quickly, and then let's get to the public comments. Steve?
Sorry, I'm taking my hand down.
Oh, you took your hand down. Okay. So let's turn to our very patient members of the public. Thank you. Mindy, I believe you had your hand up first. Mindy Lane.
Good afternoon. Thank you for letting me comment. I had some thoughts about, I agree with Todd, and I'm happy to see the direction that the law is going with more clarity and more bumpers and less gray area. On the other hand, I also second what Emily Gothard said about some of the things about putting down a 25% deposit. A hypothetical scenario that I'm thinking of is for agencies who don't have an online payment portal. It sounds like, if we can't charge up front, we can only charge up front for a deposit. It's going to be a handwritten check that comes in through the mail, that goes in through the mailroom, and then goes into accounting, and then a receipt is delivered to public records staff. And then essentially, if you're doing all that work and then they decide that the requester doesn't want the records anymore, then, it's going to be even more work to go back to accounting to issue a check from DAS to mail out back to the requester to refund. Just one of my thoughts on that subject. I don't know any solutions and I don't have any suggestions. I'm just thinking of the potential for more work. And then the second thought I have about the 25% deposit, sounds like you can only ask for a deposit if you know which exemptions to cite by the time you've delivered a fee estimate. And unfortunately, I'd have to disagree with Todd that we would know at the time of a fee estimate what's in there, and that we wouldn't have much work to do after the fee estimate is provided. It's not uncommon where some of my record searches pull up thousands and thousands of emails, and I've often been surprised by what records I found that are exempt from disclosure. Never would have guessed. So it's hard for me to imagine a scenario where I'm giving a fee estimate and I have a complete picture all the time of what's in the records that I've gotten. Those are my only comments. And again, I thank you for your time. Thank you for having me.
Well, Mindy, thank you for testifying. It sounds like you're with an agency. Would you mind letting us know what your agency is?
Yeah, sure. I'm with the Oregon Water Resources Department, and I am the public records coordinator.
Oh, excellent. Okay. Can I ask you a question? I know you said you didn't have suggestions or solutions or anything, but at the moment, I'm sure you actually probably have lots of ideas since you're doing the work every day. But do you have a sense? It sounds like you don't have an online payment system. Is that right?
That is correct. Our agency does not have any payment portal online for public records.
Do you have payment portals online for anything?
Not that I'm aware of, no.
Okay. So the only thing you would need a payment, like the only way you take payment is, the only thing you take payment for is public records, or do you take payments for other things?
Our agency does take payments for lots of other things, and as far as I know, we don't have any online payment system for any of the transactions that we perform.
How helpful would it be for you to have a online portal for all this to deal with?
It would be really expensive. DEQ is just started.
That's not my question, and I was not asking you. But how helpful would it be?
If you're asking my opinion, personally, yeah, I think it would be a huge benefit, but I also know that it's extremely cost prohibitive.
I mean, everything's expensive till you pay for it, and you get a better system in all of our lives as well as in government. Okay, Joe Barker, you were next to offer some comments. Please go ahead.
Thank you, Madam Chair. Earlier, to coin a phrase of Tyler, I'm going to circle back here a minute. Earlier in the discussion, dealing with the comments from the public, I think also Steve echoed this, to make comments either directly to the vice chair or the chair. How would the public go about doing that other than going through Todd? The second question or comment that I have is that I have to agree with you, Emily, on the putting the agency in charge of the aggregate issue, based upon a simple scenario of if a person makes a records request, let's say they want to see 1 year's worth of utility bills, without specifying whether it's water, electric, or sewage. Okay, so you get one portion of the utility bill, you get water, then you have to go back and request the other documents to go with it. Let's say that the records request is not totally complete, where there's items missing, so you have to keep going back clarifying. Under that scenario, you would have an aggregate issue of 5 requests in 1 week, where when the request was made clear in the first place. The other issue is if on the fee structure itself, I don't have a problem with the standard cost for a document. Okay, I don't have a problem with under 10 pages free. My problem comes with when you allow discretion of the agency to, in addition to the cost, then they charge per minute as well as per hour charge. It has to be a clear delineation of you either charge this way or you charge this way. And in order to be able to accurately assess what a records cost for a single page or a cumulative page, you're going to have to do a system development charge analysis, i.e., how much kilowatts are used for this machine? How much does a piece of paper cost when you buy 10,000 sheets in a box? How much does the ink and toner cost? How many pages do you get out of the ink and toner? Okay, now you start.
I know two other people who also want to make comments, and we're running out of time. So this, I just wanted to address your question about how to suggest specific language. And yes, the appropriate way is to email Todd, and then he and I,
Thank you.
Earlier, we'll compile things together. So thank you very much. So whatever, if we put up a deadline for that, it will be publicly posted, as well as distributed to the members. Thank you for joining us again today. Nicole Tate, you have your hand up. Would you go ahead, please? We have about 3 minutes left to try to close the meeting out on time. So I'm sorry if you're squished, but please go ahead.
Can you hear me?
Yes, thank you.
Okay. So I'm from the Astoria Police Department. We're a tiny police department up in the upper left-hand corner of the state. And I guess I just wanted to say, I think, of course, I love new systems. For us, not just the cost of the system is prohibitive, but also in a small rural town, it's difficult to find people with the technical proficiency to be able to manage those systems. So we run into that for the systems that we have now. We don't have an online system to track records requests, or we kind of just email them back if we have files electronically or scan them if people want them, which works fine. but we don't even have like a credit card machine in our office. So there's a lot of other nuances that would affect us. I guess I just wanted to share that with you because I imagine it's the ability of people of different agencies to respond varies greatly between the rural and urban areas. And I would like people to have all of the same access across the state, but also trying to find a way that's to advocate for a fiscally responsible way for us to be able to do that. Because, you know, taking a hit of, you know, $10,000 to $15,000 for our department is very significant.
Well, and what cost, or sorry, what is that? What's that number represent?
If we were eliminating, like the majority of our records requests are going to be like under, I would probably say under even 5 pages. So what we would be talking about is, I mean, unless somebody's coming in and asking for like typically one of our permanent case files, which are the larger ones, it would be fairly difficult, especially a lot of ours are other agency requests. So we get requests for backgrounds or face sheets on for, you know, DHS or backgrounds for other agencies who are trying to hire. And I also had some concerns with making sure we can respond to those in a timely manner, because I don't want to back up, which I feel like many cities are already, and agencies are having a difficult time with, the hiring process. So I definitely don't want to sit on those ahead, or, you know, if there's a way to not include those in the tier process, that they aren't getting pushed back ahead of other things, I think that would be really important for public agencies. So that was all I really wanted to add right now. But
okay, sounds like it sounds like what I'm understanding is you're saying that there may be some worth in separating out records like that from the public records system, records like a agency doing a background check. Am I understanding you correctly?
Yeah, I would appreciate that, because it would give us the ability to expedite some of those requests. If they're, I don't know, it's the tiered process, I think, is really complicated, and I think it has some value, but trying to determine which requests should be expedited, I think, is going to be quite a challenge, at least for the ones that we see.
Okay.
You know, I want things to be publicly accessible, but I also want to make sure that police departments have enough, you know, officers to do their job too. So.
Yeah, and I want to make sure that you can get payments easily when you're trying to take payments, and people can pay in a efficient manner. It just seems a little out of the total scope of this committee, but thank you, Nicole.
Yeah, exactly. Thank you so much.
Yeah, it's 3 o'clock, and I know some people have a very hard out here. I see Steve's hand up, and Simon Clayton, or Clayton Simon, you also have your hand up. I'm here to stick around for 5 minutes and make sure this continues as part of the record. But if people do need to go, I understand that. I think, Todd, you said you had a hard out. I think that does still leave us a quorum. And anyway, we're just going to be listening, not making any decisions.
Well, I was going to say, I have to get the recording rendered, which I can't leave until I do. But I'm happy to hang around for 5 minutes. So I could just quickly respond to Nicole as well to help maybe alleviate some of her concerns. Requests from other public bodies, including requests for background searches for law enforcement attempting to hire within their own agency, aren't public records requests and wouldn't be impacted by implementing a tiered system for public records requesters. So a public body can prioritize or do whatever it has to with those agency requests separate and apart from the public record system now, or if and when the cost system is reformed for public records. Just an FYI to try to be helpful.
Thank you. Okay, Clayton, Simon Clayton, please. I'm sorry, I don't know which one is your first.
You're not the only one that does that. I promise I'll be very fast.
Which one's right though? Tell me.
It's Clayton Simon.
Okay, thank you.
Don't worry, everyone at my agency gets it wrong too, so it's okay. Thank you for allowing us to participate in this process. I recognize this is not something that's easily done, especially with everyone coming at it from different areas. For us, I would say we'd be in support of clear direction and definitions for what can be charged and how it can be charged. But I also like what Tyler said. I think that there should be some discretion built in there, because I think that most of us we're all coming from a good place. We want to be able to help people. That's why we're in this profession in the first place. And so to be able to maybe find a creative solution to satisfy a request for maybe someone who doesn't have the resources to do it, I don't want to take that out of that equation. With respect to something that was said earlier, gathering the records, that is a lot of work. There's no doubt about that. But performing the next steps like redaction, documentation, looking at the media, getting legal reviews for all of that takes a substantial amount of time. So please do not discount that, especially for smaller agencies. Well, even larger agencies, I don't think it really matters. It's a lot of time. And when we're looking at this, records, we tend to think of them as just written documentation, either electronic or paper, but it includes all digital media now. And that is the thing that law enforcement is dealing with. And talking about body cameras, we're talking about in-car systems, and that is a bear to redact and comb through. So just please don't forget about that side of it. Thank you very much.
I think we have heard you say that already today. Thank you. It's the body cam stuff I know is a system that definitely needs some fixing. We've heard testimony from journalists and lawyers about that as well. So thank you very much, Clayton, for being here. Steve, you had your hand up. It went down. Just checking in. We have 1 more minute to honor.
Yeah, I was just going to suggest that we move to the last item, and there's not really even any time to discuss it, but I just want to throw out there, next meeting, I propose that a first agenda item be re-examining the calendar. I think we're going to have to look at more meetings and maybe shorter ones. So.
All right, thank you. Anybody want to adjourn?
So moved.
Okay, second. Thank you. All in favor?
Aye.
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 Okay, have a great weekend, everybody. Todd and I will be telling you about deadlines shortly. Thank you.
Thanks.
Thanks.
Bye.